Welcome back to The Narrative. I'm your storyteller, Callistra Farrier. Well, 5 years ago, a water company in Grenada, the Montpure Mineral Water, took on the SpiceMas Corporation of Grenada. The incident was over sponsorship rights. Montpure was told they could not sell their water at official SpiceMas events, all events managed by SpiceMas. The CEO of the company, Rolanda McQueen, took issue with that. There was a bit of controversy and drama when she went to the SpiceMas office to challenge them. That matter did not go to court, but what went to court was a legal challenge to the decision by SpiceMas to give exclusive sponsorship rights to a competing water company, excluding all other bottled water companies from having their product at official SpiceMas events. Now, Justice Glasgow in the High Court in Grenada recently handed down a judgment, more than an hour and 45 minutes. He presented the judgment and he ruled in Montpure's favor. SpiceMas is said to have acted unfairly and discriminatory in the manner in which they handle the sponsorship rights issue, and the judge ruling that in future that it did not follow procedures. However, the Public Procurement Act, which was one of the aspects that was brought before the court, the judge ruled that that did not apply. Now, joining me on the narrative is Ruggles Ferguson. He represented Montpure's interests at the High Court in this matter. He's joining me now to talk about the judgment, exactly what the judge ruled and what it means for sponsorship issues regarding SpiceMas and other public corporations in the future. Welcome to the program, sir.
Good day, Callistra, and nice to be on the program again.
Good to have you on. Well, I guess congratulations are in order. You won this one. What exactly does the judgment say? What did Justice Glasgow rule on this matter?
Okay, well, first of all, it's important to understand the background to this whole matter, which arose in 2019. The judgment has only just been delivered, but it's a matter that goes back to 2019. And basically, what happened by way of just factual context is that since 2018, September 2018, Montpure expressed an interest to SpiceMas that it wished to be a sponsor for Carnival 2019. So that was since 2018, months before, probably close to a year before the actual Carnival 2019. And we know Carnival takes place every year in August. That has not changed over the past decades. So they expressed an interest in being one of the sponsors for Carnival. And they followed up with several calls, but SpiceMas Corporation was not ready at the time, did not have their systems in place to consider sponsorship and to address these issues. So eventually what happened is that the standing sponsor, a competitor of Montpure, was eventually announced sometime in March or April publicly to have been the sponsor of SpiceMas 2019. The water sponsor, because you have different categories of sponsorship. And what essentially it meant is that the Montpure could not sell its products at the key SpiceMas events, as usually happens with sponsorship. And more importantly, on Carnival Monday and Tuesday, on the designated route outlined by SpiceMas, they could not sell their products along that route. So the vendors, neither themselves nor the vendors could sell their products. So basically what they did, Montpure did, was to challenge SpiceMas's exclusion of Montpure from the sale of its products during the Carnival period, and more importantly, on Carnival Monday and Tuesday on the road. Because one of the things that we have to understand is that probably water is the most important product for Carnival. From the young, the very young, to the very old, drink water. It's the neutral drink for Carnival, and it's a time and opportunity for all to make additional money during that particular period, which is the single largest cultural event in the country. So it was against that background that Monk Pio essentially went to the court and said, listen, you have treated with me unfairly. I expressed an interest. I was not subject to any process, or you had no process out there, and then you arbitrarily selected my competitor to the exclusion of me to be the water sponsor for Carnival. So that, in essence, in a mouthful, is the factual background to it. No, so that's one aspect of it. The other aspect of it is the judgment, and we, as part of the relief sought from the court, was a declaration that SpiceMas did not follow the procedures laid out in the Public Procurement and Disposal of Property Act, a 2014 act in Grenada, and that as a public body, they were subject to that act. One, or alternatively, they didn't follow the what you call common law due process of fairness as a public body. So what the court essentially ruled primarily is that the Public Procurement and Disposal of Property Act did not apply because they were raising money and as opposed to spending monies. Um, and so that was the ruling of the court. We held a different view, of course, and but they agreed with the fact that one, SpiceMas as a public body ought to have had very clear procedures regarding sponsorship. One, these procedures ought to have been advertised and published to the public. And three, water persons interested or entities interested in being water sponsors would have an opportunity to apply, an equal opportunity to apply, and those applications would be considered and a selection made thereafter. So, and of course that was not done. So they basically ruled that SpiceMas breached its duty, its common law duty to act fairly, and made that important declaration. Now, this is a matter between SpiceMas and Monkpio and SpiceMas, but it has implications in relation to all public bodies, and that's the importance of the judgment, really, because public bodies ought to understand, unlike a private body or private entity, that when you are a public body, there is a duty imposed on you by the law, whether it is what you call old common law or judge-made law over the years, or whether it is established by statute, that you have a duty to act fairly. So if you put all of this in context in relation to SpiceMas, here you have the single largest cultural activity or even activity for the year, which is SpiceMas. It attracts visitors from all over the world. It's an activity that attracts visitors from all over the world. It brings a significant injection of cash into our economy. And people and entities from all walks, whether it's companies or individual vendors, look to SpiceMas to capitalize on their revenue, their income in a particular year. And here it is that a company then, because the normal sponsor every year, no problem with that. They then decide, well, listen, we'll go with this sponsor because time is against us, and we need to move. So let's just select the sponsor from last year. In public law, that cannot happen when you're dealing with a public body, because first and foremost, the onus is not on the entity that wishes to be a sponsor to come and beg you and call you every day to find out what is happening. That is not, once you are a public body, that's not how the system works. And in fact, the evidence presented by SpiceMas Corporation is exactly the evidence that we used, because there were differences in facts, the factual contentions. But in essence, in the most important aspects of it, is really the evidence of SpiceMas we use to invite the judge to rule a particular way. Because if you are a public body, you then must establish guidelines as to how this operates, especially for an important event as Carnival. How do we get everybody out there who wish to be a water sponsor on board and to give them an equal opportunity to be our sponsor? This is not a private body. If you are a private body, then it's different. But once you are a public body, and as I say, whether it's SpiceMas or a different entity, the same principle applies.
And so is it the last minute decision? This is what they presented to the court, that they were out of time, and that they simply just held on to the sponsor they had the year before? Is that the evidence that you were able to use?
Well, in essence, that's what it came down to. That you invite, here it is, the very first entity that applies since in September 2018. That entity applies and says, I am interested in being a sponsor. You are the public body. Carnival is coming in August 2019. It's a fixed date. It's a date that does not change. And therefore, you must have systems in place to ensure that at the end of the day, you are fair in your dealings as a public body. That everyone or each entity who can possibly be a water sponsor have the opportunity. Now, they may ignore that, they may not wish to be water sponsors, but you must give everybody an equal opportunity, and that is what did not happen here. In other words, the kind of evidence was that, listen, SpiceMas or Montpio said it was calling regularly all the time, but he wasn't calling that regularly as they say they were calling. And there was a particular meeting in February when in which they were invited, and they did not show up to that meeting. And of course, SpiceMas Montpio, because there was and Montpio tried to get another meeting date. But what they did is to try to place the onus on Montpio, not on themselves, but on Montpio to basically, as I say, run them down to see if, I could really get a bly in this thing called SpiceMas 2019. But when you are a public body, that's not the way you operate. You must have very clear and transparent rules up front. You must publish those rules. You must invite applications. You must set deadlines. And then you must make an objective choice. And what happens by doing so, by introducing that element, is that you allow for greater competition and, in fact, greater sponsorship. So that is what our position was, that there was actually no procedure to be followed. And so with these things, what you have is the same sponsor who was there 10 years ago, I'm just using an arbitrary example, would get to be the sponsor 10 years from now because they're already inside and nobody is bothering with the rest, even when the rest expresses an interest in being part of it. But as I say, the rest don't even have to express an interest. In Monk Pio's case, they expressed the interest in September. But whether or not they express an interest, if you want to exclude now a water company from your major event, major carnival event, at least you must give them the opportunity to apply and be a sponsor. Now, they do that, they go through a process. And a sponsor emerges to the exclusion of the rest. Certainly, you can do so. Because there was a fair process through which every entity was subjected.
And during the case, the hearing of this matter, was there any evidence presented or uncovered to suggest that there was corruption in the awarding of sponsorship rights by SpiceMas?
No, not at all. And in fairness to SpiceMas and the folks who operated in SpiceMas, I think what they more depended on is what they met there. The procedures that were followed before, which of course were not the right procedures. And that is where some guidance, and they would not have been equipped with the necessary technical knowledge, if not guided, or if you don't have very clear regulations to guide them, then they basically, you make the rules as you go along and you operate based on what you instinctively believe to be the right thing to do. But when you are a public body, there are rules. And in this case, you have the SpiceMas Corporation Act. And as I indicated, there should be regulations, and the judge recognized that there ought to have been regulations to give guidance. But in the absence of the regulations, you develop policy and you put systems in place. It makes life easier for you, and it makes life easier for those who have to deal with you. And so, the folks there are hard workers. In fact, it's disappointing that this matter had to reach this far. This is my own disappointment with it, because I think it could have been resolved some time ago through engagement and discussion, especially when the Monk Pio indicated quite clearly that, listen, we want to be part and parcel of Carnival. They indicated quite clearly, listen, we don't want to be the alternative sponsor or sole sponsor, because we recognize that water as the main commodity for Carnival. You have several water suppliers, and Grenada alone does not have the capacity to supply all the water required for Carnival. So essentially what Monk Pio was saying, there is room for everybody. Just give everybody a fair opportunity. Don't just give one person and then you exclude the others on the main days when you expect high sales for Carnival. So there was that aspect of it. And I think what is required now is that the SpiceMas sit with the legal folks, and despite the fact that there was no ruling in relation to the Public Procurement Act, and it says it does not apply, it is a very useful act. It's a very useful act, and it sets out certain procedures there, some of which can be adopted, and you never know in the future what position would be taken as far in another case with respect to the Public Procurement Act. But it provides a good guide. The SpiceMas Corporation Act does not have the kind of regulations required to give the guidance. So regulations ought to be created.
Can we describe this ruling as groundbreaking though? Does it set a standard?
Well, it's certainly it's groundbreaking. You know, in these okay, I didn't hear your last question, but I heard the part where you said groundbreaking,
Yes,
and I'm saying,
that's my question. Can it be considered groundbreaking?
but it can be considered not really groundbreaking in terms of defining the law, but is more groundbreaking as far as the applicability of the law is concerned. Because that's why the challenge was made in the first case. You have a situation where a water company says, I am interested, close to a year before Carnival, in being a sponsor for Carnival. And you actually have that water company being ignored, and a new sponsor or a sponsor being appointed without any process being followed. But more importantly, it is not, and that is what public companies or public entities need to get very clear. When you are a public body, the rules applicable are different from a private body. And therefore, you have to set the rules. You have to put the standards in place. And then something as Carnival, you then have to say, listen, we extend applications for sponsorship. Not that you're working out with some private entity who should be the sponsor. You work out, these are the rules, you apply by so and so deadline, these are the criteria that you must satisfy. You give everybody an equal opportunity to apply. People apply. You give objective consideration to the application, and may the best man win in those circumstances. And even where the best man wins, that's the other aspect of it. You still have to find a way to try to work with other entities, especially where it's your biggest event, not just cultural event, but probably Carnival is the biggest event of the year. And it stretches over the longest period from May to August. It being the biggest event, and you're talking about you having a monopoly over that biggest event, the biggest event, you have to make sure that there is some flexibility there to ensure that everybody is able to raise some good revenue over the carnival period.
Because in the case of the water sponsorship, what SpiceMas did was grant exclusive rights to a single water company. They didn't have tiered sponsorship. Like you would get a level of visibility at gold sponsorship and silver sponsorship and bronze, which is done sometimes.
Precisely.
It was exclusive.
Right.
No one else is even allowed to put an empty bottle from a competing company anywhere near anything that SpiceMas had its hands on. So the exclusivity, I think, was a part of the problem there as well. Now,
yes, and that's an important point. And that again emphasizes why you must have a process, even more so when you are going to do that.
now Moncpure did not. The judge did not award damages. He ordered costs, legal, but did not award damages to Moncpure. And people are asking, well, why was all of this worth it? She didn't get any money out of it, but suing SpiceMas for monetary damages was never the end game in this case, was it?
No. In fact, Moncpure, yes, Moncpure made it very clear. In fact, throughout this process, and that's why, again, I thought there should have been some accommodation and a showing that you really want to settle this matter. Because really and truly, the opportunity was there to build new alliances with new entities. And Moncpure always said, listen, we are not saying we should be the sponsor or we are better than the sponsor, and therefore we want to be the sole sponsor. That was not Moncpure's objective. Mount Pure was simply saying, listen, there's a role for everybody, given the high demand for water and the capacity to meet that demand locally. So if the thing is done properly, everybody can benefit. So the focus was not on a monetary focus. Um, there it was more a position, because what is the more important issue in this case? The bottom line, as I would say, is the guidance going forward given to an entity that has a monopoly on carnival to say you have to get it right. If you don't have the procedures, you must create the procedures. And when you create these procedures, they ought to be known to all. When you are inviting sponsors or sponsorship for carnival, you must make it open. And by that, just by doing that, you can raise significantly more money and prevent a situation where the government always has to come to the rescue. I think
and
what
and
happens,
always bail you out. And I think in this instance as well, we're out of time, but let me just say in this instance as well, my understanding is that the exclusive sponsorship rights was granted for, I think it was $10,000 or $12,000, which and water and product and $12,000 in cash, which seemed like a bad deal to begin with anyhow.
right? It was a relatively small. In fact, I was taken aback when I heard the sum.
Relatively small for what was being given, which is visibility, exclusive visibility for a brand in the biggest festival that the country has, an international festival with attention and everybody, and we gave it for $12,000, and in the absence of any sort of process to try to have others offer more for it. So yeah, but we are out of time. I want to thank you so much for joining me on The Narrative to speak about this issue. And congratulations to you and Mount Pure once again. Thanks for being on.
Yes, thank you.
This is The Narrative. I'm your storyteller, Callistra Farrier, speaking there with Ruggles Ferguson, attorney at law. He represented Mount Pure Mineral Water, the Grenadian company which took the SpiceMas Corporation to court over the awarding of sponsorship rights for SpiceMas. The genesis of this is way back in 2018 when SpiceMas Mount Pure, expressed an interest in becoming a sponsor. They were virtually ignored by SpiceMas. SpiceMas then allowed an old sponsor to remain without any attempt at looking at other options, and of course denying all water companies the opportunity to sell at any SpiceMas event, including on the carnival routes. Well, a judge has ruled that that was unfair and that SpiceMas needs to put proper systems and regulations in place to allow for fair decision making in the services that it seeks. More when we come back.